People will say, well, Adam, 2 crimes is worse than 1 crime, right? So I should just give a breath test, right? The weight of the government, they're beating me down. Let me just cooperate and give it. Not so fast, my friend, okay? You need to really understand the little nuances between it. Attorney Adam here to break down Florida's new Trenton's law. It goes into effect on October 1st of 2025. And basically what Trenton's law does is it does really 2 things. It gives enhancements for second offense of DUI, manslaughter, vehicular homicide, basically boating or driving cases that kill somebody. And what it does is it makes the first time that you refuse a breath, blood, or urine test a separate crime. It's called Trenton's law. So who is Trenton? Who was Trenton? Trenton Stewart was an 18-year-old kid. He was a college student. And in 2023, he was killed in a drunk driving accident in Jacksonville, Florida. And what happened was the person that had killed him, the driver, had already served a 10-year prison sentence for a separate vehicular homicide case. So this was a repeat offense. Now, under the previous law, there was no enhancement for a second or subsequent vehicular homicide, DUI, manslaughter. So that person was still looking at the max, which was 15 years in prison for the killing of Trenton. Now what this law does is it gives enhanced penalties. So if you were convicted of a DUI or a BUI manslaughter, a vehicular or vessel homicide, and you get arrested again, instead of looking at 15 years in prison again, now you're going to be looking at up to 30 years, okay? It doubles it and makes it a first-degree felony. So look, these kind of cases are rare, but this enhancement is a very significant and serious enhancement for people who have now had a second, vehicular homicide, DUI, manslaughter, etc. Now, the second part of this bill, which is not as sexy or making all the news headlines as the first part about the enhancements for DUI manslaughter, okay, is a change to regular DUI law. And this part of the bill is going to have the most impact on normal people and the most amount of people in our daily lives. And what this means now is for a first DUI arrest, we're not talking car crashes, we're not talking injuries, nothing like that, but for just a first DUI arrest, if you refuse a breath test, now you're going to get charged with a second or additional crime. So there's always going to be the DMV penalties and there's the criminal case. And I always tell people, I say, look, there's a left hand, the right hand, they're separate, they're apart, they're both connected to my body. My body in this case would be the facts, right? So they're connected, but they're different. This does not affect the DMV process, the 10-day rule, and what you need to do there. That's still in effect. It's still majorly important. And just for anybody watching this, if you have a DUI, you must call a DUI defense attorney and hire a DUI defense attorney within the first 10 days. It's essential. But what this law does is it changes a little bit on how these cases are going to be prosecuted and handled by the criminal courts, by the prosecutors, the judge, and how we're going to defend them as DUI defense attorneys. So what it means is you're going to get arrested for an additional crime. So you're going to have at least 2 criminal charges against you, one for the DUI and a second one for refusing a breath test. Now, there's no additional charge if you give a breath test, okay? But if you refuse, even a first time, it's a separate charge. Prosecutors can be using this separate charge to maybe manipulate you or manipulate the case or try to gain an upper hand in prosecuting you. But the big question that we've gotten is, well, so does this mean I can't refuse a test anymore? And that's not what that means. You still have the ability to refuse a breath, blood, or urine test. You can still say no, thank you. The only difference or change is, well, you're going to get arrested for a second crime instead of just the DUI. So people will say, well, Adam, I'm not, I didn't take calculus in college, but 2 crimes is worse than 1 crime, right? So I should just give a breath test, right? The weight of the government, they're beating me down. Let me just cooperate and give it. And what I say is not so fast, my friend, okay? You need to really understand the little nuances between it. And here's how it goes, okay? The criminal DUI charge has all these mandatory minimum penalties, and what it does, if you get convicted, it starts the clock, meaning that now you have a prior DUI, and if anything happens in the future, well, now it's a second, or it could be a third, and it can trigger additional mandatory minimum penalties. It could make it a felony. So in all of our cases, one of the most important things is to avoid a criminal DUI conviction at all costs. Okay. Now, when you give a breath test, it makes it harder to avoid a criminal conviction at all costs. Great DUI lawyers know how to beat breath cases. I talk about it in my book. I have an entire chapter on how us at the Rossen Law Firm, how we win and beat breath, blood, and urine cases. Okay, so check out the book. It's Florida DUI Law. It's a 200-page book written for normal people like you, not written for lawyers and judges. Okay, it's easy to read, easy to understand. But the big major premise is, let's not defend against something if we don't have to. It's always better to not have to defend against a breath test than to say, well, yeah, I gave this breath test. Yeah, I was twice the legal limit, but the machine's wrong, but it's calibrated wrong, but there's all these issues. It's better to just say, there's no breath test. Right? There's no urine test. There's no chemical or scientific tests that show that this person would be impaired. Okay. And so when we're looking at it, it's always easier, I think, and better, I think, in order to not have to defend against that than to defend against. And I always tell my clients, I say, look, the easier our job is, well, the higher likelihood of us winning your case that we're going to have. But then there's another crime with additional penalties. Well, yes, but it's a second-degree misdemeanor. Instead of a year of probation and a year of jail, the max is 60 days jail and 6 months probation. Now, some people might go, well, hey, Adam, I don't want to spend another minute in that place, so 60 days is still pretty bad. Yes, of course, I get it. But the likelihood of a judge or a prosecutor giving you jail time on this first refusal charge, especially in South Florida, especially in Miami, Broward, and Palm Beach counties, is highly unlikely. And that's also why you have us to provide mitigation, to negotiate, to really defend and do all these things for you. So while I'm not allowed legally to tell you to refuse a breath test, because then I'd be telling you to break the law, but what I can tell you is, if it were me, knowing what I know, right, I would make an intelligent, thoughtful decision, and my intelligent, thoughtful decision would be to politely refuse to take any breath, blood, or urine samples if it was me. Of course, you folks can make your own decision. I'm a huge believer in personal choice, but I also believe you can't have full and personal choice unless you know everything there is to know about the law, about the process, the procedure, and your choices. So the choice is yours. Give the breath test or refuse the breath test. Either way, you've already been arrested. You're not going to be let go if you give a breath test and you're under the legal limit. That's something they don't tell you. So if you're in this situation, call us either way. We have a team of expert DUI defense attorneys that can help you out no matter what your DUI situation is. So now you know that. Let me know what you think. Put some comments in there. We read them all. We want to hear it. Like this video, subscribe for more tips, tricks, information about criminal defense cases in Florida and nationwide, state and federal. Okay. If you have any issues at all, call us at the Rossen Law Firm. We'd love to help you. 754-206-6200.